The third case in the sequence is Minerva Mills versus the Union of India. So basically, Minerva Mills was a textile limited company of Bangalore, Karnataka, dealing primarily in textiles, and seeing its working, the government had its doubts from the beginning onwards that the company was not working efficiently, and thus it would be better if the company was instead nationalized. So the government on August 20, 1970 set up a committee for investigation into the matter under section 15 of Industries Development Act 1951. Once the committee was formed, the committee studied the case and submitted its report on January 1971 to the government. Upon receiving the report, the government passed an order on October 1971 authorizing the National Textile Corporation Limited to take over the management of Minerva Mills, as it was working in the interest detrimental to public. So it insisted the National Textile Corporation Limited to take over the company under Section 18 Section 18A of 1951 Act. So thus the company was nationalized under the provisions of Sikh Textiles Undertakings. Under the provision of Sikh Textiles Undertaking Nationalization Act 1974, and once this decision was made, this takeover was challenged in High Court, but was consequently dismissed by the High Court. Later, it was challenged in the Supreme Court by filing a writ petition under Article 32 of Indian Constitution. So the primary issue in front of the court was whether the Section 4 and Section 55 of 42nd Constitutional Amendment destroy the basic structure of Indian Constitution or not. Secondly, also the can DPSP coming under the Part 4 of Constitution have primacy over fundamental rights. This was the second issue which the court was facing. So at that time, before this Minerva Mills case, the parliament already suffered massive defeat in the Indira Nehru Gandhi versus Sri Raj Narayan case, and thus in order to make its power once again supreme, the government passed 42nd Amendment to bar any challenge on constitutional amendments in courts of law. So through 39th Amendment Act 1975, Parliament inserted Nationalization Act 1974 into 9th schedule, which basically means that any challenge on the said act was outside the purview of judicial review. So from the side of the Minerva Mills Union, the petitioner Nani Palkhiwala challenged the constitutionality of Section 5 Clause B, 19 Clause 3, 21 Second Schedule, 25 and 27 of the Sikh Textile Undertakings Nationalization Act 1974 in front of the Supreme Court. He also challenged the order of central government dated 19 October 1971. He also challenged the Section 4 and 55 of 42nd Amendment 1976, and he also raised issue over the primacy given to directive principles of state policy over fundamental rights. So basically these were the issues of the petitioner, and the arguments made by petitioner in this regard were that amendment powers of Parliament are limited under Article 368, and this amendment, the amendment in this subject, would make Parliament the master of the Constitution, which shouldn't be the case. Also, he said that the court's decision in Keshavanand Bharti case already mentioned that Parliament has no authority to disturb the basic features of Constitution. He also said that it was an obligation on the state to pass laws on directive principles of state policy, but it should be done through permissible means and shouldn't overrule the fundamental rights. Due to Section 55th of 42nd Amendment 1976, no court would have the power to review constitutional amendment passed by Parliament. This would basically and clearly damage the balance between Parliament and judiciary. He also raised the issue that because of this judgment, a disbalance has been created between the fundamental rights and the DPSP. He also said that in such a sequence, almost every law enacted by the government would in one or the other way be associated with directive principles only, and to basically give immunity to directive principles over fundamental rights would wipe out Article 14 and Article 19 of the Indian Constitution completely. So in regard to this, the arguments again made through the respondents' sides were the advocates through the respondent sides were Ellen Sinha, Attorney General Ellen Sinha, and the additional solicitor K.K. Venugopal. The arguments made by respondents were that the Article 31C of Indian Constitution reinforced the basic structure doctrine, and directive principles just provided goals in absence of fundamental rights. They also argued that any harm that is caused to fundamental rights won't amount to violation of basic structure doctrine. They said that there is the issue that the achievements of goals framed under DPSP should be supreme, and thus no restrictions on Parliament's amending power should be entertained in this regard. They said that the government through the nationalization process was just assisting the company to raise loans. They also emphasized, the respondents also emphasized on Article 38 and argued that any law in compliance with Article 38 just couldn't abrogate the fundamental rights or destroy the basic structure, as the structure is founded on justice, social, political and economic principles, and Article 38 enumerates upon the same. So these were the arguments made from both the sides, and the judgment in regard to this made by the court was given on 31st July 1980, and the decision was pronounced by a 5-judge bench of Supreme Court with the majority of 4-1. So the majority opinion was presented by Justice Y.V. Chandrachud on behalf of Justice A.C. Gupta, N.L. Untwalia and P.S. Kailasam. So their decision on Article 368 was that Parliament has the amending power but should be within its basic framework. They said the theory of unlimited power so they said that the theory of unlimited power to amend constitution would alienate democracy and create a totalitarian state. They deemed clause 5 as unconstitutional because it hampers the basic structure of constitution. They also struck down the clauses which were limiting the court's power of judicial review on the constitutional amendments. On Article 31C, the majority was of the opinion that if Part 4 subverts Part 3 of Constitution, it would destroy the basic structure, and elementary freedoms which were given under the Article 14 and 19 must be preserved in any case. They also said that Article 31C has removed two sides of the golden triangles. The golden triangles being Article 14, 19 and 21, and Article 31C has just removed Article 14 and 19. If this happens, this will cause serious harm to the people of this country. They said that the part 4, that is the DPSP, needs to be achieved without the abrogation of part 2 of the constitution. And also finally the minority opinion was given by Justice Bhagwati, and on his opinion on Article 368 was basically the same as of the majority opinion. He was in favor of majority in striking down section 55 of 42nd Amendment 1976. He opined that the basic features are an integral part of the constitution. He also deemed clause 4 as unconstitutional because it breached two basic features of constitution. First, the amending powers of parliament, and second, it did put a restriction on the judicial review of the courts. He deemed clause 5 as unconstitutional and void because it had an effect of transforming the constitution into an uncontrolled one. But on Article 31C, Justice Bhagwati was of the different opinion from the majority, in the sense that he said that Article 31C didn't damage the basic structure but instead strengthened it. And he was also of the opinion that non-compliance of directive principles of state policy would be unconstitutional and a breach of faith with the people. Thus, no law directly giving effect to the directive principles can be inconsistent with the vegetarian principle. So these were the majority and minority opinions in the case, and the final decision was that section 4 and section 55 of 42nd amendment were deemed unconstitutional, and the other things, the writ petitions, the writ petition from the petitioner side challenging the validity of section 5 subclause B, 19 subclause 3, 21, 25 and 27 were all dismissed by the court. Thank you.